Ladies and gentlemen, welcome back to the IndieZoNe. My name is Kathy. The defense filed their objection to the state's motion in limine regarding text messages and testimony, arguing that these items are inappropriate hearsay. They cannot be admitted into evidence because they're out-of-court statements that are offered for the truth of the matter asserted. And they challenge the state's position that the text messages between DM and BF, the surviving roommates, should be thrown out, that they're not excited utterance, which is an exception to the hearsay rule prohibiting hearsay from coming into court cases, nor are they present sense impression, because these text messages went on for a period of several hours. Let's see what the defense is offering here. Page 1 comes now Brian C. Kohberger by and through his attorneys of record and objects to the state's motion in limine to admit text messaging as requested in its motion. Mr. Kohberger's objection is grounded in his constitutional rights of a fair trial, due process, confrontation of evidence as guaranteed to him in the 5th, 6th, and 14th Amendments to the U.S. Constitution and Article 1, Section 13 of the Idaho Constitution. And it's saying here the state is seeking a broad scope of cell phone records for two stated purposes. One is to establish a timeline, and the other is for the truth of the statements contained in the record. The span of the time that the state seeks to encompass is about a 10-hour time frame. The state indicates the initial text is the beginning of the time frame at 2:10 a.m., and that text is not offered for the truth of the matter. Similarly, at the end of the time frame is a text from the University of Idaho at 1:04 p.m. The state grounds its request in the rules of evidence and a previous decision by Judge John Judge. They go into the law of the case. Basically, what they're saying here is that although Judge Judge made a ruling that appeared to be favorable to the state, this court is not bound by Judge Judge's prior ruling. The defense goes on and says that this court's not bound by that decision. And then it goes into excited utterance and present sense impression. These are the two exceptions that the state was asserting got these text messages out of hearsay and made them something that could be presented into evidence at the trial. Well, the defense has an issue with that. It says here, although the rule does not expressly state factors of trustworthiness and necessity play a large role in a trial court's decision whether to admit a declarant's expression of his state of mind or whether to exclude it under IRE 403, that's a rule of evidence in Idaho, as well as in the decision whether to admit or exclude the content of additional statements accompanying that expression. Both exceptions require the statements to be contemporaneous with an event and be spontaneous without time for reflection. So in other words, let's just say somebody takes their finger and puts it on a hot stove and then says a few words. That's happening at the very time that whatever the trigger is. And there's no time to think about it. There's no time to make up a story. It's what the person was, an excited utterance or a present sense impression of just having their finger get burned. What's really interesting, beginning on page 4, they then say, Mr. Kohberger herein provides a more complete but not exhaustive view of DM and BF's communications and interactions with social media during the hours established by the state. Now, we didn't have very much that led us to conclude that there was any social media communications during this time frame, but Mr. Kohberger is claiming that there was, and he's saying here, I'm going to provide you with more complete information, with more texts that the public has not seen before now. And then, but he's saying here, this is not exhaustive of what went on. So there may be other things out there that, for whatever reason, Mr. Kohberger is not including here. Now we begin. It's towards the middle of page number 4, and it goes into the next page. November 13th, 2022. Starting at 2:10:29, DM text to E.G., the Uber driver, inquiring if he was driving. 213:00, e.g. text to DM confirming he was driving. 253, MM calls BF. Now, this is the first time that we've learned of this. We knew that MM, who's Madison, was along with Kaylee's phone attempting to get a hold of Kaylee's either ex-boyfriend or boyfriend. Some 351:03 DM creates a new contact in her phone. No further details. BF calls DM. 420:00 DM calls XK. 420:20 DM calls KG. 420:28 DM calls BF for 41 seconds. 421 BF calls XK. 421:50 DM calls MM. 422 BF calls MM. 422 BF calls EC. 422:08 DM to BF. No one is answering. 422:11 DM to BF. I'm RLLY, confused RN. Next page. 422:42 DM to KG. Kaylee. 422:43 DM to KG. What's going on? 423 BF outgoing message via Snapchat. 423:15 DM to BF to DM. Ya dude, WTF. 423:15 BF to DM. Ya dude, what TF. 423:28 BF to DM. Xana was wearing all black. And then 423:33 DM to BF. I'm freaking out RN. 423:42 DM to BF. No, it's like ski mask almost. 423:48 BF to DM. STFU. 423:41 BF to DM actually. 423:52 DM to BF, like he had something, it looks like this is misspelled. Over is for head and little ND mouth. 424 DM to BF, Bethan, I'm not kidding. OM, so freaked out. 424:07 BF to DM, so am I. 424:11 DM to BF, phone is going to die F. 424:14 BR to DM, come to my room. It appears that that is a typographical error, that should be BF, not BR. 424:22 BF to DM, run. 424:27 BF to DM, down here. 424:39 DM calls EC. 424:58 DM to BF. 425:16 BF to DM. There's no text here. It's unclear what is stated here in terms of a text or if this was a call. Next, 427:11 DM outgoing call. 427:30 DM outgoing message, Snapchat. 427:40 DM outgoing message, Snapchat. 427:47 DM calls KG. 428:44 DM calls XK. 429 BF calls MM. 430 BF calls MM. 430 BF calls KG. 431 BF calls KG. 432:57 DM texts KG. 434 BF accesses Snapchat. Page 6. 437 BF accesses Instagram. 7:30 BF calls dad. 8 BF calls dad. 8 BF calls another number. 8:01 BF calls home. 8:02 BF calls mom. 8:09 dad calls BF. 8:05:43 through 10:45 DM is on Instagram. 8:41 to 8:42 BF takes photos of what we don't know. 9:04:36 mom texts BF. 10:56 to 10:01:40 DM messages, incoming and outgoing via Snapchat. 10:01:53 to 10:03:05 DM is on Instagram. 10:03:30 to 10:04:02 DM is on Indeed. 10:04:54 to 10:23:02 DM messages, incoming and outgoing via Snapchat. 10:23:23 DM text MM. 10:24:01 to 10:25:04 DM on Instagram. 10:30:18 to 10:45:43 DM messages, incoming and outgoing via Snapchat. 11:21:53 JM text BF. And it's unclear because the next message says 10:56:49 to 11:29:08 DM on Instagram and messages on Snapchat. Why that other message of JM texting BF and who that is comes before the 10:56 number. In any event, it then goes on to say 11:29:27 DM texts KJ. 11:29:41 to 11:32:45 DM is on Instagram and messaging on Snapchat. 11:35:36 DM is on Yik Yak. 11:36:07 DM is on TikTok. 11:37:36 DM messages Snapchat. 11:39:09 to 11:40:14 DM and her dad text. 11:49 BF calls JM. 11:50:55 JM texts DM. 11:44:06 to 11:50:38 DM is on Instagram. 11:50:58 DM calls EA. 11:51:01 JM texts DM. And then we continue on, ladies and gentlemen, to page 7. 11:51:07 BF texts JM. 11:51:33 JM texts BF. 11:51:36 JM texts BF. 11:51:40 BF texts JM. 11:51:47 JM texts BF. 11:53:52 BF texts JM. 11:53:53 BF texts JM. 11:53:55 BM texts JM. 11:54:57 to 11:55:01 JM texts BF, and there's 3 texts here, ladies and gentlemen. It states 11:54:39 to 11:57:01 DM is on Instagram. 11:56 BF calls 911. The state has selected, defense says, text messages as excited utterance and present sense impression. The totality of circumstances defeat the state's request. BF and DM texted each other a handful of times, and then they were in the same bedroom. We don't know at what time, though, ladies and gentlemen. That point is unclear. They were together with the ability to talk to each other. They were not asleep for 8 hours. The messages the state seeks admission of as exceptions to hearsay began with a call and a message about being confused after texting each other and unsuccessfully speaking with any of their roommates. The pair were together. The state is looking at the messages with the benefit of hindsight. The analysis has to be done in the moment the utterances were made. Text messages in this case. DM first claims confusion, then after communicating with BF claims fear to leave her room. Despite her stated fear of leaving her room, she does so and joins BF downstairs. To get into BF's bedroom, DM passed the front door of the residence. BF was steps from the front door. Neither of them left the house. Neither of them called friends, family, or law enforcement for help. Instead, both have a substantial amount of activity, beginning in earnest less than 4 hours after DM made her way into BF's room. BF and DM communicate with friends and parents, and DM is on social media. This is the bottom of page 7. Continues. The second grouping of message, the state claims fit within the exception to hearsay rule, are those from DM to her roommates beginning at 10:23 a.m., 6 hours later. The state claims DM woke up and realized her roommates had not responded to her earlier texts. The state is wrong. Defense comes right out and says, DM was awake. She was messaging on Snapchat. She was on Instagram and she texted with her dad. And this is not an exhaustive list of activity on her phone. She was with BF, who was also communicating with her parents, and then later friends. And it concludes, Mr. Kohberger urges the court to view the state's request with consideration of the complete picture. The state has asked the court to look at a timeline, and Mr. Kohberger urges the court to look at everything that occurred during the timeline. The state's motion should be denied. This is dated the 17th of March, 2025. Ann C. Taylor on behalf of Brian Kohberger. We now await the state's response to this, which will be in the form of a reply due on or before March 24th. So, ladies and gentlemen, I would suggest let's wait to see what the state comes back with here. The defense has filled in a lot more of the gaps that the public were not aware of, and it does seem to, in my humble opinion, cast doubt as to this is hearsay. It's not excited utterance or present sense impression, because it seems to have gone on for a very long time. We await the state of Idaho's reply. If you have any questions, comments, leave them here. Until next time, this is Kathy. Thank you for joining us here today.